I don't know how an officer can radar the car in front of me and radar me at the same time. That's what the officer told me, and the officer's not
Okay,
even present. So
okay, hold on, hold on.
But
Okay.
I like to tell the situation. What was that? So the
Well,
since
wait, hold on. So we have two options here. You can either avail yourself of the deferral option, which I just explained to you, or we can move forward to a trial. But those are two choices, and you have to decide now which path you're going to go down.
so with the but the thing is, officer, the car I was driving, that car is not mine. I'm not the owner of that car. So here I like to tell you the situation, what happened, because I don't have no control over the car.
Okay, so but you were driving the car. That's going to be the court's order. This concludes your matters.
That's fine.
and
But
I'd
wait,
like
that
to-
takes us a
I'd like to thank you. I'd like to thank you for, sir.
Oh, you
I'd like
shut
to
the
thank
fuck
you.
up and let me
I'd
talk
like-
for a moment.
Hey, don't speak that way in court.
What are you gonna do? Throw me in jail?
Yep. Okay. Go! Will you hand me my screen box? Now go. Preach. Rah.
Start off with number one on the docket, Matthew Batchelor. Matthew Batchelor, please go ahead and unmute yourself. State your appearance.
I'm right here.
Yeah, right. Thank you for unmuting yourself. You are, looks like you're charged with speeding 5 miles over the limit. I see you've already exercised the deferral option within the past 7 years, looks like in 2019. So you're not eligible for a deferral. How would you like to proceed today?
I don't know how an officer can radar the car in front of me and radar me at the same time. That's what the officer told me, and the officer's not even present. So
okay, hold on. So I take you want to contest that citation, is that correct?
yes,
All right. So go ahead and raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth?
yes.
Okay. So we'll start off by looking at the evidence against you that I have here in the court file. The officer's report is admitted into evidence, and the report that I have reads as follows. Headed to take daughter to school, running late, said he thought he was going about 60 miles per hour, was also warned for following too closely. A vehicle in front was also stopped for speeding, claimed defendant was tailgating him, and had no valid proof of insurance. So that is the statement that I have from the officer that constitutes the evidence against you in the case. At this point in time, feel free and go ahead and present your testimony.
I have valid insurance, and I was not speeding, and I was not tailgating the guy. I was 4 cars behind him. The cop come flying by me, scared me, because he just came out of the blue. And I have my insurance, it's Progressive, and I have it on my phone at all times. The officer told me that he radared me and the other car because I was going to go by him. It was at County Line Park. He pulled over, stopped in the middle of the road, and told us to get over. So I just followed him. And he told me that he radared me and the other car at the same time, and I was 4 car lengths behind him.
Okay, any further evidence or argument that you'd like to present?
No.
Okay, I do have actually. There is one other note that I do see here in the court file. It does note that says actual speed checked at 68 miles per hour, although you were only cited for 5 miles over the limit. And I didn't mention that earlier, so I'll give you a brief moment if you have anything to respond only to that point.
No.
Okay. Okay, based upon the evidence before the court and defendant having made no motions, I'm going to go ahead and find the violation committed. Violation amount will be $119. If you need time to pay, you can go ahead and contact the court clerk's office and they can set you up with a payment plan.
Okay.
All right, this concludes your matter for today. Thank you for your appearance.
Mm-hmm.
Okay, next matter is number 6 on the calendar, Daryl McWilliams.
Good morning, Your Honor.
Good morning, Mr. McWilliams. Let me go ahead and pull up your case in the computer.
I apologize for being in bed. I'm not feeling well, but I'm here with a good appearance in the background. So
Okay, well, it's not inappropriate, so that's fine.
Okay. Did you receive my motions to dismiss both cases? First question.
I believe I've got a copy of that in the file. Let me go ahead and pull up some papers here from the court file. One moment.
Yeah, there should be two cases on today, and they both have motions for dismissal and all that filed into them.
Do we have two cases on for? Oh yeah, I see. Number 6 and 7. Okay, got it.
Yeah, you should have 5A0490039 and 5A0424973.
Okay, I do see your motion to globalize and to dismiss.
Yeah,
Please stand by while I take a chance to look that over.
go ahead.
Okay, Mr. McWilliams, I have reviewed your motions and your motion to dismiss the cases against you is denied. Do you have any other argument?
Yes, I would like to set this matter over because there's a case currently ongoing, and I will cite that for you. It's Master Sergeant Charles Fields, my father, case number 25201-292-08 in the Superior Court. It has jurisdictional authority over this matter. It is currently handling ex parte motions of stay of relief. I also have other criminal cases where I have an attorney who's motioning the constitutionality of the order plus getting a sound expert. I would ask to defer today's hearing to a later date to allow those motions and orders of Superior Court to proceed and allow my attorney the opportunity to have the prosecutor removed as well as argue the constitutionality of the legal ordinance modification. Just so you know, Your Honor, I responsibly in the beginning of the year took accountability for a charge of playing music because I DJ, and a prosecutorial agreement was made. And then suddenly, months later, they illegally modified the law without applying to the Department of Ecology pursuant to RCW. So there's a lot of moving parts right now. And rather than argue today or bring witnesses, if you're going to deny my order on the face of, I would ask that you allow the Superior Court time for the case that I cited to make a ruling over its jurisdiction in this matter, also allowing my time for my criminal attorney to finish her filings so that I may copy and apply them into this case as they have revolving facts and similarities as well as a question of the constitutionality of the law. So I would ask that this, based on her presumption that the constitutionality argument will take 1 to 2 weeks to get in and then heard, I would ask that this be set over for a month, at which point I will bring witnesses and I will supply the court with more evidence, including any other filings or orders that the Superior Court chooses to dismiss this on the merits of which we motioned.
So I do find that both of the cases that are pending this morning's docket were filed and notice was mailed. Well, in one case earlier in September, and in the other case was filed towards the end of September, and the notice was mailed on October 1st.
Yes, but there's been an ongoing barrage of police abuse.
Sir, I'm speaking. It's currently December 10th. I do find that that's adequate time for you to have prepared your defense. I also noticed that your attorney is not appearing on your behalf today. You may have an attorney in other cases, but it appears you don't have counsel in this case. I've considered the argument that you've raised, and I'd like to, at this point in time, understand if I'd like to hear if you have any further argument or testimony that you'd like to offer.
Yes, the citations that are before you lack police training because they were reading in DBC and not DBA, and the law is specifically cited as DBA as the measurement, as my expert witness will testify as well. So the two citations before you today, sir, were unlawfully measured in DBC and not accurately to DBA. Myself, Charles Fields, and Logan Fields, who I can get mustered up right now for testimony, were there when we tested sound decibels and we have a scientific measurement. I master all my sounds through a software called Platinum Notes. So they're all measured to negative 11.5 decibels. So when the board is set for sound, each song is exactly the same. And I've also built a $7,000 acoustic wall since the first charge. I've taken steps and liberties to ensure that I'm not a disturbance. However, the cases before you in these two violation codes, I believe one of them was for violating the decibel readings. However, the officers have already admitted on camera to me and on the record that they were reading in DBC, which is a different compression and more sensitive and not reflective as the law states of DBA. And I believe the second one was for motor vehicle noises or sirens and horns, which doesn't apply to this situation. So it's a illegal law that doesn't apply to what was going on. Unless I'm standing wrong, there's a lot of them. These both could be the ones where they just read in DBC. So with that said, we have a problem because the law states DBA. So the ones before you, I believe, are unconstitutional and inaccurate based on the evidence. But I am a disabled, vulnerable adult, and I've been subjected to violent crimes and abuses over the past 60 days. There are multiple protection orders granted for me as a vulnerable adult. That's why I would justify to you, Your Honor, the continuance based on the special circumstances, not your review of the calendar. But I'm happy to cite every case right now to you to show you that I've been busy protecting me and the custodial rights of my minor children and my adopted vulnerable adult son, Logan Fields, who also participates in the music. The music is for therapy purposes, of which my doctors will testify. I made a prosecutorial agreement and I stayed within those sound decibels, but unfortunately, the officers in the beginning were reading them in DBC. Even Officer Yeager himself shows his DBC reader beside mine in a video, which I didn't have time to get before you because my life has been in danger. But in that video, he shows, oh man, we have been reading in DBC and not DBA, because showing even on my porch, I'm within those EDNA Class A residency levels, which is between 7 a.m. and 10 p.m. You could be 55 decibels and under. You can exceed decibel limits for 15, 10, and 5-minute segments by certain amounts of decibels. In this case, I would be testing scientific equipment like Serum 2 presets. Sometimes when you try a preset, it fires off louder out of the decibels when it's a DAW plugin, which is the digital audio workstation. So no effort or angle of any of my music has ever been meant to disturb or annoy anybody. But I do believe in the two citations you have that they were decibel reading oriented. And at that time in training, those officers were reading in DBC and not DBA. And I was following the prosecutorial agreement at all times. What we've run into now is several more charges which are being challenged because after the prosecutorial deal, they then modified the law without applying to the Department of Ecology and made it where the neighbors have discretion. And since then, they've been abusing it, up to 9 charges now. And I've had to get protective orders from them from trying to run me over with their truck. They're making threats against me. They're slandering and libeling me. There's an open civil case against them, as well as the Master Sergeant Fields versus City of Castle Rock. They have retained a really big law firm, and right now we have filed motions even today in court for ex parte to address this case among the other several noise violations. So I would ask, based on the evidence alone within your police report, that the officers lack training and knowledgeable understanding of decibel measurements, and we're not accurately reading and reflecting that. I know this because I volunteer a lot of my time with churches for LED walls, stage, and their concert developments. And for the audience, we have to keep it below 92 decibels for a certain amount of time exposure, or it could damage hearing. I'm very knowledgeable in measuring decibels, and I've taken every step to make sure I'm not violating the law since I first agreed to a prosecutorial deal in which I accepted guilt without even having an attorney. But now that the city has taken to egregious conduct, we are out now motioning for a special prosecutor because even prosecutor Christopher Eastwood said he's out for my blood, and he said it in front of the mayor or the Grimm Law Group when they were representing me until a neighbor broke into my house and tried to assault me, and now the Grimm Law Group represents her. There's a lot of conflicting conflict and overlapping facts, and it all originates with the city and improper decibel readings, trainings, and legal modifications to the law. So while these things are ongoing, I would ask that if you read the police report, you'll notice that this is a decibel measurement training lacking, that they were coordinating at that time in the wrong measurements. Because any other time after that, once they went from DBC to DBA, the officers acknowledged that I was within the sound limits. And I have what I call the cop line on my Flex 10. It's a DJ controller board, and I have it marked so that way I know I'm always within the decibel limits, even after installing a $7,000 acoustic wall. I've made every effort to make accommodations, not only for my needs as a vulnerable adult defined by Washington state and federal laws to be able to play sound for therapy purposes, but I've tried to create a safe environment for my community. But the neighbors have taken to making false allegations that I have a gun and I'm pointing at them, and extreme egregious acts that I am a felon as a felon and I cannot have guns. So I am objecting to these actions that are being done to me. So right now, there's kind of a lot of things revolving. That's why I asked in my motion to globalize the cases, because there's training aspects to address, there's laws and ordinances to address, and more importantly, there was no motor vehicles, sirens, horns, or anything like such taking place, like further citations. So I would ask this court dismiss this on the basis that the officers acknowledged that they were reading in the wrong decibel compression
Okay,
format.
thank you for summarizing your motion, Mr. McWilliams. Your motion to dismiss is denied based upon the evidence that is set forth in the officer's report on the case ending in 4973, as well as the case ending in 0039. The court does admit into evidence both of those officer reports. And based upon that evidence, I will find the violations committed on
Have you, before you
case
say
number
that, have you find those
4973.
violations so I can
Sir,
appeal them?
sir, you absolutely can appeal my ruling.
Yeah,
There's
but give
no
me a
issue with that
reason
at
and
all.
don't be a
Uh,
baby about it.
no, there's no issue, sir. There's no issue with that at all. You contact the clerk's office. You can file your notice of appeal. On case number 4973, the violation amount is $103. And on the case ending in 0039, the violation amount is
So
$257.
what
That'll be the
evidence?
court's order for today.
What
And
evidence are you citing as the basis against my actual legitimate legal motion? You're saying the
the
officers
evidence
that
is
are
what I
being
just the
sued?
evidence is what I just cited to, which is the officers' reports in both matters, which the court has admitted into evidence. In response to your question, that is the evidence
You're
against
taking
you.
sworn officers that are being sued in a federal lawsuit for face value when they've been targeting and attacking me, and you're
That
going to
constitutes
justify
the
it.
evidence against you today. That's going to be the court's order. This concludes your matters,
That's all right.
and
But wait, that takes as a
I'd like to thank
one-sided
you. I'd like
police
to thank you
statement.
for,
Oh,
sir. I'd
you
like to
shut the
thank you.
fuck up and let me
I'd like.
talk for a moment.
Hey, don't speak that way in
What
court.
are you going to do? Throw me in jail?
Well, if you were here, it might be an
I bet
option.
you wish you could. You know what? Give me a real reason. A one-sided police
Sir,
report.
sir,
A judge has even said a
sir, I don't
one-sided
want to
police
have to find
report
you in
is not
contempt.
evidence.
Okay?
For
I don't
what?
want to have
Being
to find you in
disabled and under
contempt.
duress?
This concludes your matter for today.
My First
You're
Amendment
free to
rights?
disconnect at this time.
Yeah, you're
Thank
a
you.
coward. You're a coward. You're a coward. Remember that.
Okay. Well, next item on the docket is Rajveer Singh, number 12, Rajveer Singh.
Hello.
Good morning, sir. Let me go
Good
ahead and
morning,
take a
ma'am.
let me just take a look at a couple things here in the computer. All right, sir, it does appear that you're eligible for a deferral. Would you like to avail yourself of the deferral option today, or would you like to move forward with the trial?
Deferral.
Okay. So
Uh,
you
uh,
were charged. Oh, go ahead,
Excuse
sir.
me, my bad. So I want to know about deferral. I don't have too much knowledge about it. So I like to know what is deferral and how it work.
Sure. So the way it works is since you were charged with an insurance violation, you're going to need to provide proof of current insurance to the court along with a deferral application, which is available on the website, and a fee of $150. You don't have to have insurance that was valid at the time of the violation. Your insurance just has to be valid as of the time that you send in your application paperwork. That way, instead of paying the $564 and having the matter go on your record, if you go for 12 months without having any future violations, then the matter gets dismissed. It would be a $150 fee. You have to send in the application and your proof of current insurance, drive for 12 months without getting any violations, then the matter gets dismissed and doesn't go on your record, and you don't have to pay the full $564 fine.
All right, thank you so much for that, Your Honor. But
Okay.
I like to tell the situation. What was that? So the
Well,
since
wait, hold on. So we have two options here. You can either avail yourself of the deferral option, which I just explained to you, or we can move forward to a trial. But those are two choices, and you have to decide now which path you're going to go down. So do you want
all
the
right.
deferral or do you want the trial?
So with the but the thing is, officer, the car I was driving, that car is not mine. I'm not the owner of that car. So here I like to tell you the situation, what happened, because
Oh,
I don't have no
oh,
control over the car.
okay. So, but you were driving the car, right? You're
Yes,
driving the car and and you weren't able to provide proof of insurance. So we can either have a trial on that and you'll be able to tell me your testimony, and at the end it'll turn out the way it turns out, or you can exercise your deferral option right now. We don't have to have the trial. You do the process I just explained, and that gets resolved that way. So which option, again, for the last time, which option do you want, the deferral or the trial?
I think I go with the trial, officer.
With the trial?
Yes, yes, Your Honor.
Okay. So have you had a chance to review the evidence against you in this case?
Okay, so since the day of infraction, uh, I wasn't the driver. Initially, I was the
Okay, sir, I'm sorry. Maybe you need to focus on my questions. Are you, have you had a chance to review the officer's report in this case yet? Is that something you've seen?
yes, I saw that I got a ticket for driving under uninsured vehicle.
Okay. And you've had a chance to review the officer's report in that case?
Uh, you like me to check the report which I got?
No, I'm asking if you've had a chance to see. Never mind. I'll just read the officer's report into the record. Okay.
All right.
So Saturday, September 27th, 2025, I was performing assigned traffic duties in Cowlitz County. I'm currently assigned to District 5, Detachment 11, driving a fully marked patrol vehicle and wearing a department issued uniform. I'm a trooper with the Washington State Patrol and have been fully commissioned since November 2nd, 2017. I stopped the defendant for front passenger had an unsecured child on her lap. Upon contact, the defendant was unable to provide valid proof of insurance. Defendant statements. The front passenger advised they did not have insurance. Two unsecured children were in the vehicle. The traffic stop was audio and video recorded. This information contained in the citation is incorporated by reference into this report. I declare under penalty of perjury under the laws of Washington the foregoing and the accompanying reports, copies of documents, and the information contained therein are true and correct. Okay, so that evidence constitutes that report constitutes the evidence against you in this case. The court's admitting that into evidence. At this point in time, if you have testimony or argument to present, I'm going to swear you in. So go ahead and raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
Okay,
I
please
will tell the
proceed.
truth. Okay, so the date of infraction, I was a passenger initially, and after driving for 1.5 hours, the driver, who is a owner also, she start feeling unwell and she's vomiting continuously, and also she say I feel fainted, maybe due to a long drive, and she requests me if I can drive the car that moment. and I was the only person at that moment who have a driver license except her. And to ensure the safety for us and for the road, I started driving the car. And because of the woman next to me, she put a baby on her lap. We got pulled over by the cops, and the result came out that the car don't have insurance at that moment, which I was not aware of. I was just trying to ensure the safety of us and for the others. Since I'm not the owner of the car and I don't have any car at all, but I got the citation driving under unauthorized and uninsured car. And I like to say the quote that I'm a full-time student. don't have no job and I don't have no employment at this moment. And I like to request court if the court can waive my fine or at least make it reasonable so I can pay. Because paying $564 with no employment is next to impossible for me at this moment. And I like to request you, Your Honor, if you can waive or at least make it little less so I will be able to pay this citation.
Okay, well, thank you for that testimony. We did start off the hearing with a deferral option, which would have been only $150, provided that you successfully complete the 12 months and get proof of insurance. You declined that option, so now we're here on a trial, and the penalty amount is the $564. So as much as I wish we could go back and go to the 150, unfortunately, that's no longer an option. I am looking right now at my screen on RCW 4630.020. It is very clear that no person may operate a motor vehicle without being covered under policy of insurance. Doesn't mean that you necessarily have to have the insurance in your name if you're not the owner of the vehicle, but you have to be protected under a policy, presumably that would be purchased by the vehicle owner. A lot of insurance policies, the way it works is whoever's authorized to drive the car as a general matter is protected under the policy. But you also have to be able to provide that proof at the time that you're stopped by law enforcement. And in this case, you weren't able to do so, which in fact you've admitted you weren't able to do so. And so I have no choice but to find the violation committed. The fine amount is $564. I understand that it is a significant financial burden, and you can contact the clerk's office to make payment arrangements or look on the website for a payment plan. So that is going to be the court's ruling today. I mean, you've basically admitted the violation. I have no choice but to find it committed. $564. I do thank you for your appearance today. This concludes your matter.
Can I request judge to reduce the fine because paying that fine is next to impossible as per my situation right now, being a full-time student with no job and no income. That will be very hard for me if
There is a process when you received your citation to have requested a mitigation hearing. Unfortunately, you didn't request a mitigation hearing. That would have been a chance for the court to reduce the fines. Again, there was also the deferral option earlier at the beginning of today's hearing, which you declined. At this point in time, since there was no mitigation requested as a preliminary matter and the deferral was not elected, at this point I'm boxed in. You know, there might have been some other avenues that we could have went down earlier, but right now the only thing I can do is find the violation committed at 564 and refer you to the clerk's office to set up a payment plan. I'm sorry, sir. You know, again, you've got to read all the instructions carefully when you get the citation in terms of how to request mitigation. And again, I did explain the deferral process earlier today. You decided not to do that. So right now we've only got one. Given the fact that you've admitted the violation, we've only got one option. So I do appreciate your appearance today, and this concludes your
Judge,
matter.
I'm sorry to interrupting you, but Your Honor, I already write a letter to court for mitigation hearing.
Oh, somehow it didn't get set for a mitigation hearing. Let me take a look at the docket.
Yes, I think that was a misconception because I write a letter for mitigation hearing, but court send me letter for contested something.
Okay, I'm going to take a look at the court file. One moment.
Please, Your Honor. Thank you so much. I appreciate that.
Okay, I do see a letter filed on October 6th, does reference that you are requesting a reduction of the reduction or waiver of the penalty amount due to financial hardship. Your letter does explain circumstances. Let me finish reading it here. Hold on one second. To appear, explain my circumstances. Well, there's probably a form that the court has that is specifically designed for requesting a mitigation hearing. I'm guessing that's a form that the court has on its website. And because your request did not come on the paperwork that they were expecting, it got sent for a contested hearing rather than a mitigation hearing. However, based upon what I see here in your letter, I am going to go ahead and grant your request for mitigation. I'm going to go ahead and mitigate the fine from $564 down to $200. So the fine today will be $200. I'm finding a violation committed, but at the mitigated amount of $200. So this concludes your matter today. And it's good that you did file that, and thank you for pointing that out to the court. You're free to disconnect at this time. Have a nice day.
Thank you so much, Officer. Thank you so much, Your Honor. Thank you so much.
You're
I
welcome.
appreciate that.
Have a good day.
You too, Your Honor.
Kidding me?
Oh my God.
You have got to be kidding me! What is going on today? This is a joke. Today is absolute. It's an interpreter.
I need an interpreter when I cannot express myself somehow.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in for people to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
Times like these, they
Okay.
come and go so
There. Trust me, I'm sitting up here, I'm the one that needs a drink.